Sorry, thank you. My name is Councillor Mary Cunningham and I am the chairman of this committee. Members, please can I remind you that this meeting is being broadcast to the public via the Council's YouTube channel. Before I begin with the main meeting, I'd like just to highlight that this meeting marks our first in-person meeting since early 2020. As we move through the meeting, please can I remind everyone present to turn off their microphones when they've finished speaking. I shall now proceed with the business of the meeting. Agenda item 1, apologies for absence. We have apologies from Councillor Mrs Jenny Sandham, Councillor Mrs Jackie Pell, Councillor Paul Thorogood and Councillor Trevor McArdle. And there are no more apologies because the rest of the committee are all here. I will now proceed to item 2, declarations of interest. Agenda item 2. Do members have any disclosable pecuniary interest, other pecuniary interest or non-pecuniary interest that they wish to declare this evening? Please state the item and the nature of your interest. No, nobody has any declarations. If something comes to mind as we're going through the presentation, obviously just raise your hand. As there are no declarations, I will proceed to item 3. That's minutes of the previous meeting. Please can I have a proposer to approve the minutes as an accurate record of the previous meeting of the Partnership Development Scrutiny Committee on the 21st of July 2021. Councillor Courtauld, thank you. Can I have a seconder? Councillor Hensman, thank you. The minutes have been moved and seconded as an accurate record. All those in favour, please indicate. Thank you. The minutes are approved. Just initial them. Done and dusted. Thank you, Emma. Thank you, members. We now proceed to item 4, public question time. Agenda item 4. Members, there are no registered speakers for this evening's public question time, so I'll proceed to item 5, scrutiny review into enforcement procedures. It's our 4th evidence gathering session. And members, I would like to welcome Rachel Penn, Recovery Officer at the Council, to the meeting. Rachel's in attendance this evening in order to contribute towards the committee's evidence gathering for the scrutiny review into enforcement procedures. And she's kindly prepared a presentation which I think you've all got on your desks in front of you, which we're very grateful for. Rachel, thank you for taking the time to attend this evening and for the presentation. Could I please ask you to introduce yourself to the committee and begin with your report. And if you want to perhaps take questions at the end, or if members have perhaps in between an opportunity, are you happy to do that?
Of course, yes. If there is any questions that you would like to ask me as I go through the presentation, then please feel free to do so. Okay, so my name is Rachel Penn. I've worked at Braintree District Council for 30 years and my role is Assistant Revenues and Recovery Manager, and I deal with council tax, non-domestic rates and the recovery of sundry debtors. So I've put together a presentation for this evening in regard to enforcement action. So I'm just going to take you through some various points before we get to the actual when we pass the debt over. Okay, so if you would like to turn to page number 2 regarding the brief history to start off with. Okay, so the industry itself has been around for many centuries and dates back to the Norman times. Basically, the principle has remained the same of the role of a bailiff, and his defined responsibility is to execute the decision of a court. So during 2014, there was a major reform within the industry, and a new act was then brought in at that stage. The act is called the Taking Control of Goods, Fees and Regulations 2014. The new act recognised the need to clean up the industry and to stop road bailiffs, and also introduced the table of fixed fees. The term bailiff was then dropped as well and replaced with the title of enforcement agent, and it felt that there was a need to bring in a vulnerability policy to help people that were suffering from mental health issues or disability or any kind of things that the enforcement agent needed to know before he called at the property. So it's basically the duty of the local authority to bill and collect council tax and non-domestic rates. And we work under the legislation, which is the Local Government Finance Act 1992. So the first stage of collecting council tax and business rates is to issue a bill. If the person doesn't then pay with regard to their bill and the instalments that were due, we issue a reminder notice. If the person then still doesn't pay after this reminder notice is issued, then a pre-summons notice is then sent. Our recovery action is done on a monthly cycle. Any notice that we issue, we urge all our customers that if they are suffering any financial difficulty, to please get in contact with us. Our main aim is to get our customers engaged at any point of the recovery process, or even right at the start of the process with the bill. But if they are struggling to engage with us, to see what we can do to help. Now, after 2 reminder notices have been issued, if the bill is still not paid, then we have to issue a magistrate's court summons. Now, once again, we ask the customer to engage with us at that point, and when the summons is issued, that goes out with a special arrangement form as well as a flyer which advises the customer of the action that is due to be taken at the court, and also advises them again to make contact with us to see what we can do to help. If we have no contact at all, then unfortunately it goes through to the magistrate's court and a liability order is then obtained at the hearing. Once we've got that liability order, that then gives us the power to enforce collection of the debt. And it's at that point where we can look at engaging enforcement agents. So once we've got that liability order, before we get to the enforcement agent part, there are many different options that are open to us in recovering the debt. So our first call really would be to try and make a special arrangement with our customer directly. If we have employment details of the customer, then we can go ahead and do what we call an attachment of earnings, where an order is sent to their employer to ask them to deduct on a percentage basis an amount to be taken directly from their salary and paid to the council. We can also do this if the customer is in receipt of benefit. There are certain benefits under the council tax legislation that we can attach to. We would then at that point send a notice to the Department of Work and Pensions, who would take monies directly from the customer's benefit and then pay the council direct. The other stages that I've listed on here are from the enforcement agent, a charging order, bankruptcy, and then lastly a commitment to prison. So the latter stages are something that we don't often use and haven't done for a number of years. So our main aim is to get our customers under the first 3. And then if we cannot get anywhere at that point, we would look at sending the account to an enforcement agent. So preparing an account to send to an enforcement agent. First of all, we have to issue a pre-enforcement notice. Okay, so again, this advises the customer to firstly get in touch with us, and that basically it is their last point of call to make contact before we pass it over for the enforcement agent to do a door knock. Again, this notice goes out with a special arrangement form. Also, information on the taking of goods regulations as well goes with that, and a table of the fees that will be incurred if that action happens. It gives them 14 days. Okay. So then after the 14 days, what we then do as a department is we run a job to pick up all our customers that haven't made contact with us. Then each account is then checked before we send it to the enforcement company. And we do our own in-house compliance at this stage. So the accounts are looked at on an individual basis, and we try and make contact if we have a contact telephone number or an email address with that customer. We also check that the address that we are holding is correct at that point, and have a look back historically on the customer's account to see if previously any vulnerability issues have been identified. Has anybody got any questions? Yeah.
Yes, I was just wondering, I probably watched too many television programmes around this topic, but the enforcement agent, is that equivalent to a High Court sheriff, or, it's just, would you go to that stage? Or?
No, for council tax purposes, we use a magistrate's court, and it's then the liability order that's passed over to an enforcement agent. They're not High Court sheriffs that we use, because that can only be done through a county court. And we, because it's a collection of tax, we can only use the magistrate's court.
Yes, I was also just wondering about the average and the maximum debts that you deal with.
I have put a point in at the end of the presentation about how many we send over and the value.
Chairman, if I may just add on to the point that Rachel made about the enforcement agencies. The enforcement agencies are all certified enforcement agencies. They are properly accredited, going through the appropriate training and certification with the judicial system. So they are. This is where Rachel made reference to. The legislation that came in 2014 in dealing with rogue bailiffs, so that tightened up the enforcement agency considerably. But in terms of what we see on the documentaries, they use the High Court enforcement agencies because they've got slightly different powers to those that we engage with. They are special officers of the court, but essentially they are all accredited, certified agents, and that's been reinforced by the legislation that's brought in by 2014. Thank you.
Thank you very much.
Councillor Courtauld, yes, no, carry on.
So, Rachel, just to get this straight.
Councillor Courtauld, can you switch your microphone on, please?
Sorry, I'll whisper. So, enforcement agents, just to get this straight, are what we used to call bailiffs.
Yes, that's correct.
And bailiffs are qualified how? They get a sort of bailiff qualification of some kind, enforcement agent qualification.
They are certificated by the court. They also have to go through a training process.
Right.
Before they obtain their certificate with the company.
If I, let's say, was owed some money, I could ring up a bailiff and say, I'm owed £1,000, please collect it on my behalf. But would I have to go through the court before that happened? I mean, just... I'm not owed £1,000.
No. Okay. So the principle which the authority instructs enforcement agencies is under statute. We've got very specific legislation that deals with council tax and non-domestic rate recovery.
Right.
So we've got provision legislation. As a normal member of the public, to engage the services of an enforcement agency, you would have to issue a claim in the county court or the high court and follow that through the claim process. It's only when you've got an order of the court you can instruct the bailiff.
So it always has to go to the court.
With the as Rach said, we've got specific regulations that enable us to go direct to enforcement agencies for collections of debts.
Right. And Rachel, you mentioned the first three things you do to recover a debt: special arrangements, attachment of earnings, or attachment of benefit. And then you say, if that doesn't work, you go to the enforcement agent, and you very rarely do a charging order, bankruptcy, or commitment to prison. But presumably the enforcement agent does do those three, does he? He won't send them to prison.
No.
No, just to assist Rachel members, charging order and bankruptcy and committal have very separate legal processes which are instigated by the council. So the enforcement agency acts on our instructions to enforce the debt under the regulations, so they are working directly with the customer to make payments either in full or under an arrangement. If the debt is returned, then the authority will look at alternative recovery actions that's available to the council under the regulations, which includes charging orders, which is an application to the county court for an order which is secured against the property, or to issue a petition for bankruptcy proceedings. So the enforcement agents, I shouldn't refer to them as bailiffs, that's incorrect. The enforcement agent is one of the recovery actions the authority can take. But obviously, because you are looking at partnership working, the enforcement agency is one of the examples of partnership working through the enforcement of council tax and non-domestic rates. And charging order and bankruptcies are examples of where we use the court directly as a partnership to take enforcement action. So Rachel is focusing on our enforcement agency colleagues today.
Great, thank you. And then finally, Rachel, sorry to be so gormless. You mentioned the table of fees. So are there set fees, or is it a percentage of the debt? Or
I will come on,
you'll come
on to that. And, yeah.
I'm thinking of a career as bailiff as well. Thank you.
Thank you.
So, members, I think it's worth mentioning at this stage, and it's implicit in what Rachel's already said to you, that the collection of council tax and national non-domestic rates, as they are taxes, they go through the criminal system. So that's why they're going through the magistrate's court, as opposed to other debts that people may have, and including us. So things that are not tax related, we would take through the county court system. It's because it's specifically a tax that it can go through the other system, and also we've got the potential for committal proceedings at the end. So that's the key difference between those two debts and other debts that we as a district council may be owed. So it's really important that you understand the difference between the two.
Thank you. Can I just ask, you said that as an authority you have a special position, or you are able to go through to magistrate court. Is that every local authority? Is that county councils as well? Is it a...
No, it's the authorities who are tasked with the collection of council tax and non-domestic rates. So there's a specific piece of legislation which Rachel and her colleagues work under, which is the authority for enablers to take proceedings in the magistrate's court to obtain the liability order to secure the debt, and then through to taking action with the enforcement agency. And then there's a pathway where the criminal court then converts to a civil court, and then you take other enforcement actions, which is the charging orders and the attachment to earnings, because they are done through the civil court, not the magistrate's court. Because the magistrate court is sitting in a criminal-civil hybrid when we go. It's the easiest way to think about it, because it's the way that the statute is all designed.
Right. Okay, thanks, Emma. Councillor Hensman.
Yeah, I want to go right back to the beginning where one of the slides was, you mentioned two reminder notices, but on the slide one is reminder notice and the second one, I presume, is the
pre-summons notice. Yes, that's correct.
And I think if I remember there's a charge on there, but if the customer pays, they don't pay the charge, or is that included?
No, on the reminder notice and the pre-summons notice, there is no charge on the account. Once we issue a summons, at that point, there is a charge for the summons, and then when we attend the court hearing, there is a charge for a liability order. So at the point when a summons is issued, we charge a fee of £65. And then once a liability order is obtained at the court, there's a further charge of £30. Now, those charges are in line with our Essex Revenues Partnership Group, who, with other authorities, to keep the costs at a reasonable amount, and that's agreed with them and with the Magistrate's Court itself.
Right, so once that charge is on, it means it's actually been to the Magistrate's Court, ready to go for the hearing?
No, once the £65 has been added to the summons, that charge is for the issue of the summons.
What I mean is that at the pre-summons notice point, is that £65 on there?
No.
Right, it's the next
No,
one.
no, it's when the summons is issued, at the point when the summons is issued.
Understood.
If a customer then pays on the summons and they pay the full debt, then at that stage, that's it. It doesn't go any further. There's no further charges. At liability order stage, it just gets withdrawn and doesn't go to the court. And also, if I can clarify at that stage as well, is that the £65 is also added if a customer makes a special arrangement at that point. As a local authority, we can then give them a further period or longer period to pay over. So whereas what we try and do is negotiate with instalments running through till the following financial year, so basically through till March, we can then extend that term for anything up to a year, dependent on their circumstances. So we would ask them at that point to fill in a financial statement to see if they are prioritising debts. If at that point as well, we can refer them to someone like the Citizens Advice Bureau, so then they can look at prioritising, because obviously council tax is a priority debt.
Okay. Thank you. If you want to carry on, thank you.
Right, so where did we get to? So enforcement. We've got a strict code with our enforcement agents, so that's between the agents themselves and the local authority. So that ensures best practice under the new regulations. For instance, on the code of conduct that we have, we ensure that they're working within GDPR regulations to keep our data safe, that they are following the legislation of which they have to work under, that they investigate any complaints that customers have made against an enforcement agent or how they've been treated, and just really fair treatment of our customers. The enforcement agents also wear body cameras to protect both themselves and the debtor. Again, that's in line with legislation on the body cameras. For instance, if there is children at the property or vulnerability, then at that point, if they are requested to, they would turn them off. With regard to vulnerability, we set our own policy here within the recovery team. So if when an enforcement agent knocks on somebody's door and can quite clearly see that person is vulnerable, they would then contact us immediately. We would then put action on hold at that point and refer it to our welfare officer, who would then visit the customer directly within their home and find out what their vulnerability was and if there is anything that we could do to help them. At that point, when we've got that information from our welfare person, what we would then do is make that decision on whether to return the account back from the enforcement action or ask the enforcement agent to proceed with care. For instance, set up a small payment plan or something like that. So we feel that a lot of things are covered under the Code of Conduct. So initially, when the case goes over to the company, it has to go through a compliance stage, and that's part of the legislation that they work to. So at this point, they've received the account from us, and a fee is then charged at that first point of £75. The enforcement company have to send out a letter under the legislation which gives the customer 14 days to make contact with the agency themselves and try and put a payment plan in place or pay the debt in full. They'll also try at this point to call them on the telephone if they've got a number available, send out text messaging or email. Now, after the 14 days notice has been issued to them, if the customer doesn't make contact, that's at the point when it gets passed over to an enforcement agent for them to visit the property. At this point, there is the second charge added of £235. Okay, so at the visit, when the enforcement agent knocks on a customer's door, his remit really is to get the debt paid in full. However, he can enter into a controlled goods agreement. So this is where a payment plan can be negotiated between the customer and the enforcement agent. And at this point, what the enforcement agent would do is note down the goods that he could then collect should the debt not be paid. As long as the payments are adhered to at this time, it stops the agent taking control of goods at that point. Now, there are certain exemptions under the legislation that the enforcement agent cannot list on that agreement. So that can include clothing, bedding, furniture, a cooker, microwave. In summary, really anything that satisfies the basic domestic needs of a person and their household. For a lot of customers, their biggest asset is their car. However, again, there are exemptions where an enforcement agent couldn't note this down. So this would be if the car was under finance. Again, the enforcement agent would have to check that. Or if the car was used for disability purposes. So once the notice has been served and the agreement has been put in place, if the customer then doesn't make payment on the agreement, at that point the enforcement agent can go back to their property and look at removing the goods listed on the agreement that's been made. The enforcement agent would turn up with a van and start removing goods that have been listed on that notice. Those goods would then be sold at a private auction or by private contract, and a further fee is then charged of £110. Now, before it goes to sale, the point of sale, the goods are held for 7 days. So again, allowing the customer to make payment of the debt that's outstanding. Now, in my 30 years of working at this authority, this is extremely rare in the case of council tax and business rates that we get to this stage. Most of our customers by this point have either paid in full, stuck to the agreement that they'd made with the enforcement agents, or the case has been returned because a vulnerability has been identified. At the point if an enforcement agent can't make contact with the customer and cannot identify any goods to be listed or to remove, or even locate the customer, say they've left the address and no longer reside there. At that stage, the account is returned back to us here for us to then decide the next course of action. So if a customer has left the address, for instance, we would go down the tracing procedure. If the customer is still at the address, then we would look going back to the other alternatives of ways of collecting that debt. At all these stages, there is no cost to Braintree District Council. The fees charged are charged to the customer, and there is no return fee once the case comes back to us. Now, in relation to sundry debtors, that's a slightly different area. They, under the rules for collecting a sundry debtor, so that could be any other bill that the council have to bill and collect on. There's no enforcement action that we can take in the same way that we can with council tax and business rates, because we don't go through court action to obtain that liability order that gives the agent the power to remove goods. However, we can still use their services under a different role as a debt collector, basically. So this would be where we would send a case over to them. They could try sending the customer a letter, a text, an email, or again do a door knock. There is a fee charged for this, which is a 10% commission on any payments that they have from the customer directly. They take 10% commission. Again, with the sundry debtor side, all checks are done before we get to this stage, and we do try and make contact with as many different customers that are in this position that haven't paid the bill. Are there any questions on that at all?
Councillor Courtauld.
Thank you, Rachel. 2 questions. One is, have you got an enforcement agent's certificate? Have you done the training for this?
Personally, no, I haven't.
How big is the recovery team? How many of you are there?
Within the recovery team, there are 3 recovery officers and one lady who is a dual hat, who's a collection officer and a welfare officer. So her role basically is to identify any customers and deal with not just the collection side, but a welfare side as well. She communicates with Citizens Advice Bureau, Step Change, the Food Bank, for instance. Also here at the council we have an exceptional hardship fund. She can put a case forward for a customer that maybe come under that criteria as well.
Just thinking about the 10% charge by the debt collector, does that mean that they're only really interested in big debts? If you see what I mean. I mean, they don't, presumably if a debt's 100 quid and they'll make a tenner out of it, they're not that interested in collecting it.
They still will work with us and do a door knock.
Right.
So it's just when we employ them as a sundry debtor, debt collector, it's down to them really how they proceed. Mainly it would be a letter, a text, phone call, email. Most of the enforcement agents are self-employed and they have to earn their living like the rest of us. And it's a difficult one really, because under the council tax and business rates legislation, their fee of £235 does cover their petrol money, their time, etc. Whereas with the sundry debtor side,
may not.
Yeah.
Thank you.
Any other questions? No? No more at the moment. Oh, Councillor Mrs Walters.
Thank you, Madam Chair. Having been in the debt collection business myself many, many years ago, is there a point at any stage where you decide this is not worth the aggravation now? It's not worth spending the money on it. It's not worth actually going forward with it to collect the debt.
For what, just for the enforcement stage?
Yes.
The enforcement officer, once he's done everything I've mentioned, if he cannot make contact or there are no goods at that point, he returns it back to us.
Okay. Yeah.
And then we would then go down our other means of collection to try and reclaim the council tax that way.
Thank you.
Or business rates. Thank
And
you.
if I just may assist as well with Rachel's response to Councillor Waters' questions, there does come a point where the council has to say, is it proportionate to continue with pursuing a particular debt? And we do have provisions within our arrangements for write-off, but that is an exceptional approach, because with things like council tax and non-domestic rates, we have a statutory duty to collect that, so they will use best proportionate measures to deal with it. And as Rachel said, depending on the debtor, the enforcement strategy that we may have to consider will depend whether if they own certain assets. So if, for an example, we had an enforcement agency return a file because they could not make contact with a debtor at their property, or they couldn't identify goods that could be secured for the purpose of realising the debt, it may be that when the file is returned, we look at whether they own the property, and then we look at using the other enforcement measures which could be applying to the county court for a charging order, which would then secure the debt on the property. So there does become a point where officers will say it's not proportionate to go down this line. What are our options? That can, in exceptional circumstances, include the write-off, but officers are mindful that we do have a statutory duty to collect the council tax and the non-domestic rates, obviously because that then goes to contribute to the public services. But sundry debtors, then they have equal consideration, and again it comes a point where it's not proportionate to pursue that debt, but again, as I say, it's in exceptional circumstances. Thank you.
Okay. So COVID-19, all action had to stop, obviously due to the pandemic, and that was part of the government. It was a mandatory requirement for that to happen. So here at Braintree District Council, all the accounts were put on hold from enforcement action, and no court action was taken either against any of our payers. However, as a revenues team and a recovery team, what we did was we ran reports and picked up all our customers that had fallen into arrears. and we tried to make contact with them. So we developed COVID-friendly letters, a colourful leaflet with just basically trying to encourage people to get in touch with us and to see what we could do to help them. We signpost many of our customers to Universal Credit if they'd lost their jobs, or try to set up small payment plans with them if they had fallen into arrears because they were on the furlough scheme at that point in time. This proved very successful, and it kept our collection rate up and ultimately the services running for the council. Now, because this was a very productive way of having a softer approach, so to speak, the hold wasn't lifted until the summer of this year. So we decided at that point that, to begin with, that we wouldn't engage enforcement officers, even though they could at that point when everything was lifted by the government. We decided to keep our accounts on hold for a little bit longer to try and make contact directly with our customers who had previously, pre-pandemic, had been with the enforcement agent, to see again if there was anything that we could do that could help, because we knew a lot of people during the pandemic, their situation would have got worse, and it was just basically trying to get them to engage. So about August, late August time, we did ask our enforcement agents to continue action. However, what they decided to do on our behalf was to write to all the customers that hadn't had any action or anything from them for the last year. So the enforcement agents wrote to all the customers, regardless of the stage that their accounts were at, again with a softer approach, asking them to get in touch to see if there was anything that they could do or to make an arrangement. There was also the introduction of breathing space that came into effect in May of this year. So this is a scheme that, again, the government have brought in, along with agencies such as the Citizens Advice Bureau, Step Change, etc. And that was basically seen as vulnerable customers who experience severe financial difficulty, where all their creditors could be put on hold for a period of 60 days to give them breathing space. At this period of time, during the 60 days hold, all avenues are then explored with that customer to help them achieve the best way to deal with their financial issues. So the last page is, or page 17, is really in relation to the collection stats. So this is what we're talking at. And I had to base it on the 2019-20 figures because of COVID last year. We didn't send anything to the enforcement agents. So during 2019-20, on the council tax side, we issued 2,218 cases to enforcement, of which they collected just over £101,000. On the non-domestic rate side, there were 70 cases issued, and they collected just under £70,000 for us. On the Sundry Debtors side, there was 167 cases, of which they collected on our behalf just over £27,000. Now, based on the amounts of bills that we issued during 2019-20 for council tax and for non-domestic rates, the council tax bills that we sent during that year was 65,245. So as you can see, it's a very, very small minority of customers that we actually issued for enforcement action. And how our recovery team look at it here is, if we have to go down that way to collect the debt, we feel personally that we have failed to collect it ourselves. And I hope those figures reflect that. So in summary, as a department, we pride ourselves in trying to help our customers as much as we can before we go down any level of recovery action from any route that I've advised you of. However, sadly, there always will be a minority of customers that cannot or will not contact us for a range of reasons and circumstances. Does anybody have any further questions?
Can I just ask one?
Of course.
Do you look at other authorities' figures? I mean, is this in line? I mean, from this sounds that we actually are a very, and we know that, a very caring council.
Yes.
Do you?
We do look at other figures under the Essex Revenues Group, and we are kind of in line with a lot of authorities. We do swap ideas with different authorities as well of improving collection. One of the things that we were doing and that we kind of were testing before other local authorities pre-pandemic was, if the enforcement agent returns a debt back to us as they couldn't make contact, we have certain recovery officers that will actually do a door knock. So where we would actually go out and knock on the door and try and engage the customer that way. We would then leave a calling card and technically invite them to a clinic to say to them, look, is there something that we can do? Now, the majority of customers, unfortunately, that fall under that bracket have got issues, sadly. But when it gets to that point, we can point them in the direction of whatever their needs are. That's where we could look at involving safeguarding teams, social services, etc. So we kind of try and encompass as many different organisations as we can to help them.
Thank you. Councillor Hensman.
I've got two. One is, we often hear about the figure of collection, which is X% is then returned to other authorities because we've managed to collect more than we hope to. We have a target, I think, and then
yes,
if you exceed that, then that extra goes back. It's never 100%. So therefore, is it write-off action or non-contact or whatever that eventually is, because with it, this is one tax that is imprisonable and therefore it is the high priority debt. You always have to pay that one first alongside your rent, otherwise you lose your oath, obviously.
Yes, of course.
But then my other worry is where, if I worked it out correctly, £485 worth of fees go on, and if the person can't afford the debt in the first place, where does the £485 come from? And then if you're into arrangement, the following year you've got to find the same money, if not more again, and you're into that spiral. And I know it's like a hardship, and a lot of people just think, don't know what to do, can't deal with it. And I know with your attempts, but it's still the officialdom of it that will still scare a lot of people off. So it's just curiosity, really. Thank you.
I think, Chairman, yes, thank you.
I think that's kind of where Rachel's tried to take us through what we do in terms of balancing our role as the people that are required to collect what is a tax, essentially, and is not just on our behalf, but on behalf of a number of public services across Essex, and actually balancing that in terms of what we do, what our role is as a council in terms of our welfare role, and having worked with the council tax and NNDR recovery teams for a number of years, a significant number of years, that balance is very weighted towards making sure that whatever action we need to take to fulfil our role is done so in as supportive way as we possibly can. There are so many opportunities for people to get in touch, and we try and do that, and that's where the phone calls come in as well, just trying to kind of make contact for those people that may be struggling to make contact themselves and maybe just kind of burying their head in the sand. But ultimately, it is an individual's responsibility to pay that council tax or that business rate. So we do need to collect it, and we will do everything we can, but we cannot take away that responsibility from an individual to do it. So we also give significant funding to Citizens Advice, both from a general for general debt advice or general advice, full stop, and we also have a money advice service where we contribute. And that's well over. So the general debt advice is well over £100,000 per annum, and then another £25,000 that we give them per annum for money advice services, so that if people do find it difficult to come and talk to us about it, they can talk to somebody independent that can support them. So I think we probably exhaust every opportunity that we can to support and help people to manage that debt, but we need to remember that it is it's our role and a requirement of us as a billing authority to collect that tax. Hopefully that helps.
Thank you. Did you have a second question, Andrew, or was that?
Well, that was basically both, but interesting what Sherry's just added is that everybody thinks it's Big Bad Braintree Council, when in actual fact we're collecting on behalf of Essex and the parishes and the towns and police and fire and social services and so on. So we are because we're the ones who are tasked with collecting it, they think that it's our fault if it's gone up when it's probably not. But
Thank you. Emma, did you want to come in there?
Yes, Chairman, I was just going to remind members that the terms of reference in the scrutiny review is like what are the barriers to enforcement, sort of what procedures do we have in place, what partnerships, because you're looking at our partnerships in enforcement. Now, I think what the evidence you've had today demonstrates is that in this context, we do use partners to enforce the collection of those statutory debts. The way I describe it is we are the servant of the legislation, so we have a very specific role to play. And we have a raft of enforcement tools that we have to that we use with partners, so the agencies, the courts, etc. And I think what the evidence has been pointing to in this limb of your scrutiny review in partnership work, it's through, if I use the term, debt recovery, we don't go into it lightly. This is not something that is just a simple process. And the evidence that you've been given today by Rachel and supplemented by Sherry is that whilst we do have these partnership arrangements through the courts and under legislation, it's not something that we rush into. So we give thought and consideration and additional support. So the question is our use of partnerships in this area proportionate, reasonable? Do you think there's anything that the authority could do differently? Now, Sherry's already given you some examples of the funding that this authority gives to support charities for helping people deal with their debts, the CAB, the money advice groups, and obviously the signposting that Rachel's made reference to. So whilst we do have these partnerships that we can enter into, is it a case that we do enough stop, look, contemplate before proceeding ahead? So one of the things you might want to consider is, are we doing enough before we engage with our partners? You've had the information given to share as to how we fund those. So there's a more of a holistic approach to using our partners for recovery action before we do go down that line. So again, just take you back to the terms of reference. Are we doing the right thing in terms of working with our partners for enforcement in this particular thing? Is there anything we can do differently? Are you satisfied as a committee that we are doing enough as an organisation? Because obviously you're scrutinising what the organisation does in terms of support before going down those enforcement channels, working with our partners. Rachel's given you information that there is obviously costs associated with going down this route. Obviously the Magistrate's Court is there, but we have to pay to go to the Magistrate's Court, so we're very reactive. So again, are we going through the right procedures in addition to our statutory procedures before having to engage those partners to recover things like statutory debts or the sundry debtors? So if I just ask you to think about that when you've sort of contemplated putting all the evidence together in your scrutiny review final report. Thank you.
Can I just ask one further question? Are most of the non-payments, are they down to people who are vulnerable or suffering hardship? Or, I mean, are there such things as serial council tax evaders in our district?
Yes.
And
Yes,
what sort
there
of
are.
proportion? I mean, are we talking a few or?
I couldn't give you any actual figures. All I can say is there are some of our customers that just will not pay until they've got a reminder notice or a summons or an enforcement agent's on the door. There are some of our customers that just ignore everything, again, until somebody's knocking on their door.
So they presumably are not paying by a direct debit. They have chosen to pay 6 monthly, was it, or can you?
The bills when they go out are they're deferred over either a 10 monthly or a 12 monthly instalment plan. Then the customer has many different ways of making payments. So it could be a direct debit, a standing order, taking cash to the post office or PayPoint, paying over the telephone through the council's website. There's many different avenues that the customer can pay their instalment plan. But some people, for whatever circumstances they're going through, which could be family problems, financial issues, addiction problems, anything really that covers human life. But it's the law of the land that we have to pay tax, and us as an authority have to collect it.
So people on benefits, they are paying full council tax?
No.
No.
People on benefits, depending on what benefit they're in receipt of, they can claim local council tax support. So that's a scheme that runs alongside council tax, which is based on their financial circumstances.
Okay, thank you. Thanks, Rachel. Any other questions? Comments?
Because what's interesting for me is it's you're like the head of a spider, body of a spider, and you've got lots of legs. And to go down one leg, you have to come back to the body to go down the next leg. And it's the prescribed process that you've got that's interesting, because I hadn't realised just how many different ways you try and collect it. And before you get to, like, you think, oh, it's going to be the reminder notice, then it's straight to court, and then it's prison sort of thing. It's nothing could be further from the truth. But One thing is a lot of residents do come to us, and is there, stepping out of line slightly, is there a use for us as being out in the community as the residents' reps on the council rather than the council's rep in the community? So we are residents ourselves in our wards, and that's why I was saying about the fees, at which point when a resident has given me it and it's got that £65, now I understand where it's got to, and it's like, okay, you need to, or you should have, or let's see what we can do. And perhaps Rebs and Bens is, when I very first started, it was kind of the inner sanctum that we never went near, and if ever we stepped in there, it was, almost a mushroom farm. They were kept separate, and I think the member-officer relationship could work better, maybe, don't know, whereby, you're a marked lady, Rachel, that if I get something, I'll say, what do I do with this? And then, it comes back and say, leave it alone, we'll deal with it, or otherwise.
Of course, if anybody ever comes to any of you with a problem, you've only got to let us know. And then we will endeavour to help that customer in any way that we can. Because ultimately, our job is to get the bill paid. Mm. So, however we collect that is the best way forward for our customer and for the local authority.
Thank you, Emma. Thank you, Chairman. Chairman, just picking up on the comments of Councillor Hensman, obviously members play an essential role in the community in connecting residents to the council and the services of the council. One of the recommendations this committee may want to sort of consider is whether they should put forward something along the lines of maybe information being shared with members, so members can signpost those individuals that they they come across who are experiencing difficulty or don't necessarily understand sort of the documentation. I think all officers accept that receiving a letter from the council or from the court regarding payment of money does cause distress. Unfortunately, it is a fact of life. But if members feel that there needs to be stronger sort of support given in the community to help those, then this committee, as part of its recommendations, can look at the way, how information is shared with members, and members, again, that additional interface in the community, because people come to you for a variety of reasons in your capacity as board member, and you can have a conversation about one aspect, and in the course of that conversation, they may provide you with other information where you feel actually this person is up to their neck in other matters, and a quick conversation with one of our recovery officers may actually alleviate some of that stress that they're experiencing. So you've had a lot of information around what the authority has put in place with its funding, etc. But if you feel that a simple recommendation regarding, information that members can pass on when they come into contact with people who are difficult, to make sure that there's a consistency in that information, then that's something that this committee can consider, because you've had an awful lot of information which the officers detail what they do in the office. But if you feel that maybe a weakness in that communication is how members play a part, then that can be a recommendation to be put forward through your scrutiny report. And it could be that a FAQ sheet is pulled together for members, that it's issued to members to say, if you have somebody who is in these circumstances, or you feel maybe coming into these circumstances, these are the signposting that can be put in place. Because although we're looking at the partnership working, a lot of the evidence that you've had today is that we don't go down that route lightly. And if you feel that that can complement what we currently do, then that is a reasonable recommendation that you may wish to consider. Thank you, Chairman.
Can I just throw one last thing on that? Is one thing that we come up against is GDPR. when we try and say talk to officers, but it's a case of, well, can you please get in touch, and I'll leave it at that.
GDPR is always going to be a issue. So this is why when members come into contact with members of the public, it is always easier for us to signpost to officers, because then they can have that conversation after doing some verifications. If somebody is really reluctant to engage with an officer, all I'd say is there's mechanisms in place that would enable a member to act for that person. So never be afraid of GDPR.
Yeah, I've got a form that I filled in, and the customer has to put their details on, say, I allow this person.
Absolutely. We have 3 officers in this organisation who specialise in data protection, they being one of them, but I've obviously, but within governance, we have 3 officers who deal with these. So there is always a pathway, particularly if it means that that person is supported, educated, and put back onto an even keel. So that's something that you can consider as part of your recommendation going forward. And it's possible, if I may, Chairman, that the service already does have information that it provides that could be adapted, that can be shared with members. So if we may, on the committee's behalf, just follow up with Rachel outside the committee just to see what information is already there, because then we can then bring that back and share that with members, if we may.
Sounds good. Thank you. Thank you.
One further question. You mentioned earlier on about, I don't know whether that's in place now or the possibility of it, putting colourful leaflets through people's doors. I mean, all of these steps to someone who's not in trouble, rational, reasonable intelligence, can be quite easy to understand. But if someone is in a state of distress, and perhaps not terribly high IQ or learning difficulties, something that is easily assimilated and understood could be of help. Instead, more graphics than text. And regarding us being able to help our residents, this happened to me only once in the last kind of 14 years, and I was able to help a young person who was in a dreadful state. I was referred to him by his parents, who were in despair as to what to do to help him. He had quite a draining experience. He was in deep, dark depression, suffering from anxiety, confusion, and I really felt kind of wrung out by the time I'd left. But on my first contact with BDC way back then, which was probably, I don't know, 6 or 8 years ago, they didn't appear to, your department didn't appear to know what this person's circumstances were. And as soon as they heard from me, local councillor, then things started to go into action. His debts were frozen and collection process were frozen. I put him on to CAB, and also with his consent acted as his advocate in taking him to accompanying him to his GP to get sorted out on the medical front. It was an amazing experience, but things had clearly gone wrong. The process wasn't as refined or sophisticated back then.
Yeah, the leaflet that we designed this year basically had a signpost on it, so we tried to use graphics. We also made it dyslexic friendly as well, because we understood that there are certain colours that somebody can only see. So we tried to cover all eventualities so that when the leaflet went out with a COVID-friendly reminder notice, for instance, that would stand out more than just a letter coming through the door. And hopefully it did engage a certain amount of customers just by using that leaflet.
Could this be actually on the website, on council's website as well?
It could be something that we could look at. I mean, I know that there is a lot of information on our website, but again, if a customer is in a very dark place, it's the ostrich syndrome, isn't it? We have customers that just don't open letters because they just can't. You know, it's very difficult for us sat in an office to know exactly what's going on with people's lives unless we're informed of that. And quite often it is not picked up until they've got an enforcement agent knocking on the door, which is very, very sad.
Chairman, if I just remind members of the comments made by Sherry with the funding that we do give to the charities like the CAB and the Money Help line, because I think what we've sort of discovered through that information is that the council does acknowledge that to approach the council is difficult and that there needs to be these intermediaries within society, such as the CAB and other financial charities, where people can go and then use them as the means to talk to the authority, because sometimes a member of the public might be more comfortable setting out a list of priority debts with somebody from the CAB as opposed to an officer, even though I know that the officers will show the same care and consideration, it's just that you're not dealing with the council, the people who've issued you with the bill. So I think it's very, even though we are looking at from the enforcement side, I think you have to acknowledge the funding that goes in to basically help people in outer scenarios, so we don't have to use our enforcement partnerships for that recovery. So we're kind of turning it on its head as to how we use those. So I think you've had quite a lot of evidence this evening from Rachel and Sherry that shows the lengths that the authority will go to before we have to take those necessary proportionate steps for recovery. But is there a question mark of can we do more? Doesn't necessarily mean to be more funding, but can we repurpose, like the COVID-19 leaflet, to form a leaflet that can be shared with members that then they can hand over to people who, that they need signposting to. So this is why I suggested to him, and I'll speak to Rachel, see if we can get copies of that literature so members can see it, so then they can consider what they might want to do with their recommendations going forward. So I think we just need to bear all those good things in mind. Again, the CAB, the charities that we go to help fund, are our partners for enforcement. But again, it's not to take the action, it's to help those people not to have to go down those further channels. So it's a little bit of an unusual way of looking at enforcement, but it's almost like preventative enforcement. So it's sort of do we have the right steps in place to prevent people from finding themselves having to have the experience of the more unpleasant side of recovery action through those formal processes as set out in the regulations, which are available to the council through the Magistrates Court and the county courts and use of, enforcement agencies and the like. Thank you, Chairman.
Any further questions? No? Well, thank you, Rachel, very much indeed. It's been very, very, certainly I've found it very informative. I'm sure everybody else has. I've learnt a huge amount tonight. I think the handout that you've done has been particularly helpful because we can go through that and get ideas afterwards. So thank you so much for attending this evening.
Thank you for inviting me and listening to me.
Thank you
I
very
hope
much.
that I have given you a completely different outlook on how we collect.
Yes, it's been very, very informative. Thank you. You're more than welcome to stay, but quite understand if you would like to go.
Okay.
Thank you very much indeed.
Thank you.
So, members, based on the information gathered this evening, we now need to consider any further lines of inquiry that we would like to pursue in order to inform our scrutiny review. I don't know if any members have any ideas tonight. Any other areas of enforcement? I think we have probably covered all the ones that we originally wanted to look at, bar one, which I know Jess has indicated tonight that it was the planning of the landscape services, removal of trees, etc., which I believe we're going to have perhaps a written document on that.
Yes, Chairman. We've been working with our colleagues in landscape services to provide members with a set of responses to questions, particularly around the questions that were raised by Councillor Sandham. Her interest at the beginning of the scrutiny, which was echoed by some members, is whilst we're not looking at planning enforcement, there were some concerns about how we use partnerships for the protection of trees which are either not identified to be protected by TPOs or those which are protected by TPOs. So we are working with our colleagues to produce a document for members to have, which will then explore that a bit more fully for members and to give members a clear understanding about where we use partnerships in that enforcement role. So we will get that to members as soon as possible, Chairman.
Thank you. Jessica, were you just going to go through a little bit of the...
That's just with the next agenda item, but I can go through it now if you'd like. It's no problem.
No, that's fine. We'll sort that. So the next meeting, which is November 17th, if we could have that by then, that would be helpful. We will be starting then to pull together some ideas about how we want to prepare the report, the recommendations. I did send an email out perhaps 2 or 3 weeks ago and suggested maybe perhaps having a look at the YouTube of the previous meetings we've done. It's worth just having a look over there. I think this is the 4th, so there's 3 others. This one's particularly helpful, I think, the handout. I think is this the first time we've had a handout on this? And I must say I find them helpful. But if you want to go over the YouTube channels again, of those meetings, I think Councillor Walters missed, probably you joined us late. There was a couple. I think Jess, actually, it might be worth sending out the link.
Yeah, I can do that, no problem, Chairman. I'll recirculate those in the minutes from the previous meetings
That's
as well.
lovely, thank you. So that the next meeting... Sorry, Councillor Paul.
Yes, it was just, I forget why I missed the previous meeting. I think I was taking a short break for holiday, but I was interested in it because obviously have had 1 or 2 involvements in licensing, as have we both. And I was interested that Dan Malini's comments seem to focus more around his environmental hat rather than the licensing one. So I wondered whether the licensing side of it had been explored more.
I think it was pretty much...
Licensing wasn't a specific subject because obviously Danny Maloney's role is broader than licensing.
Yes.
So he was speaking on the variety of his functions. Now, in terms of the enforcement action, he was talking on how we work with our partnerships in enforcement in licensing. So reference was made to working with police trade and standards, the internal teams of environmental services and planning. So, and then he also sort of spoke about some other subjects. So in terms of partnership working and the terms of reference, I don't believe that there's any further need to specifically explore the licensing and partnership works, because they are common with those other areas which sit with Danny Mulaney's service. Because Danny Mulaney and Colin Batchelor came together representing the Environmental Services Department, because that is one of our larger enforcement teams, and they spoke of the partners that they work with.
It was just that there was a common theme, really, of working with the police, and I know that from my conversations with him that the relationships with the police have vastly improved over the last few years, and that's helped them with their enforcement, particularly during the COVID period, on licensed premises.
Indeed, Councillor Ball. He did speak at length how matters had improved, particularly in response to members' questions about barriers, because historically those relationships have not been as proactive as they have been. And I think Danny's reflection would be that COVID has helped to strengthen those relationships, one out of necessity, and then two out of good working, repeated working relationships, and how they then share information and intelligence to deal with enforcement actions. Chairman, the next item on the agenda is some questions that were put to officers following those sessions, because members, once they had those officers before them, we did invite the members to go away and have a think about whether there's any lines of inquiry that they didn't pursue on the evening, and obviously to sort of look at any of those, if we could put questions to those officers to answer any of those additional lines of inquiry. So, Chairman, would it be appropriate if we then move to the next item of business, just so members can see those, because obviously it fits in the context of Councillor Ball's question?
Yep. So, agenda item 6. Scrutiny review into enforcement procedures, responses to the scrutiny inquiry. Members, the report for this item is set out on pages 6 to 12 of the agenda. And can I invite Jessica to provide a brief summary? Thank you.
Thank you, Chairman. This report really is just for information purposes. Based on what you were saying about other lines of inquiry that we might look at, this report really just gives you, probably enhances what the evidence you've already had at previous meetings. So from Dan and Colin in the environmental health teams and licensing, and then from Stuart and I believe Steve Wilson in the operations team, and so forth. So really this report is just the responses that we had to the questions that Councillor Mrs Cunningham raised outside of the meeting, based on the evidence gathering sessions that you've already had. And it's just to get a bit further context around what was discussed at those sessions, a little bit more clarity. Colin and Dan have come back with several responses that have hopefully provided that. So really the purpose of this report is just for information, but if you do have any other questions from this, then, by all means, please do ask. Thank you.
If I may just draw members' attention to page 10, the final paragraph of Danny Mulaney's response to the question that was put to him about working with the police. I think that paragraph answers Councillor Ball's sort of question. Danny has commented that the work with the police is very positive, and this is partly because of how relations and trust has been developed. We need to ensure that we have good structures for this arrangement, and this can be mitigated by the impact of changes in the resources either the organisation has to maintain positive and high-performing partnerships. So when you've looked at the barriers, what are the barriers? One of the questions is, what was, how do you overcome these barriers? And I think you've had a nice piece of evidence there that it is the officer attitude on both elements of the partnership, identifying the need to work together to achieve a positive outcome. Obviously, the subject matters that Danny Molini's team look at, there's reference there to the work that they do with the animal welfare work. Obviously, they work with the police, the RSPCA and other animal charities to make sure that, they do deliver that service, and it's not something that they can do in isolation. So I think you've got a nice piece of encapsulated evidence there to show what lengths officers will go to overcome those barriers. And I would say from my own experience with working with all those teams, it really does come down to the personalities
and wanting to make it
and
work.
wanting to do it, and identifying that actually they need to go above and beyond for the greater good. I think it's fair to say that our officers have a very good work ethic, and once they've got a partner, it's about nurturing that relationship and, putting pauses in when pauses have to be put in place, but doing it in a constructive and positive way so those relationships are not damaged going forward. So I think that's testament to the officer attitude within the organisation to see the value of those short and long term.
Thank you. Thank you very much, Jessica. So I think we've got quite a lot to think about for the next meeting. Anybody got any questions or any suggestions just now before we wind up? No? Okie doke. So, members, nothing further to add. We're asked to note the responses provided within the report. Thank you, members. The report has been noted. So we'll now proceed with agenda item 7, urgent business. Members, as we have no urgent business, this item concludes our meeting for the evening. I will therefore close the meeting of the Partnership Development Scrutiny Committee at 8:42. Oh, and 16 seconds. Pass via the Council's YouTube channel. Thank you.